discuss that with our clients, but we can't hand it out. The logic behind it is that prosecution was able to show examples that of witness intimidation, where accusers, victims were approached by defendants and said, "You said this," and it's denied. Or said, "No, I never said that." They felt that there was a difference if the person said, "No, I didn't say that, I never said it," and now if the defendant has the statement in hand, in their handwriting, that may cause problem. But if the person can say, "Well, that's just what your lawyer's telling you," it was just a level of insulation that made the Prosecutors Association a little more comfortable. At the end of the day, we still have all of the material that we need to get prepared, and they still also can protect their folks. Subsection, how am I doing?
5 minutes, yeah.
Okay, all right. Subsection C2 is certification of non-disclosure. And that also is interesting. There are, as you see, certain times that they will certify to the court in writing what they are not willing to disclose. It's got to be listed out what it is and why. And so as you see here, if they feel it's going to compromise the safety of another, they being the prosecutors in the case, whether there's a substantial risk of serious economic harm, whether or not it would compromise an ongoing investigation on law enforcement technique, if it's the statement of a child under 13 or if it serves the interest of justice, they can move the court for non-disclosure. Now, the issue here at this point, there's still some discussion as to the level of review to be reported by the court. And right now it is an abuse of discretion review by the court. And both sides agree with that. There are some thoughts that it should be a de novo review. It shouldn't be quite that high a standard. But I will say that the OACDL, the OPA, and all of the groups that have kind of joined on with both positions are in support of that standard. So what would happen is, with the non-disclosed, and we're going to get to it, there's going to be actually the Rule 12K, which we'll get to in a minute. But Rule 12K kind of flushes out how we handle this. If the court says you can't see it, we'll still have the right to inspect it. So we're always going to have the evidence, and I think that's one thing that you have to remember, is we will always have the opportunity, at the very least, to inspect the evidence. What we were able to do is when we studied all of the cases and we discussed it on both sides, 90-some-odd% of the cases, you're going to get everything right away. All right, so for the most part, most people aren't going to feel any of these, these smaller subsections. Within that, potentially 5 to 8% of the cases, you can have something that's stamped that says it's got to stay with you in your office. In a very small percentage, probably less than 2% of the cases, you're going to have prosecutors potentially filing a motion to not disclose. One of those areas would be in sexual assault cases. Sexual assault cases, you would have the right to inspect in that case. The rule under subsection C3, which you have in your materials, says that you can't get hospital records. This is inspecting. Inspect means they're going to give it to you, you can look at it. I think here in Suffolk County.
Take notes regarding it?
Yeah, as far as looking at it, you can take notes. If you need to get it to your experts, you would be filing under seal. It would be filed under seal, and there would be a protective order gone from the court to your experts to take care of it. Okay. So, and the inspection of sexual assault cases, you would make a motion for those records to be sent over to your experts. So, under subsection C4, and as it pertains to this Rule 12K, here's what we have again. If the government moves for non-disclosure, the court has to have an in-camera hearing at least 7 days prior to trial. Counsel does participate in that. Both sides will be able to see what that material is. At that hearing, the court can either order disclosure, grant a continuance, or whatever appropriate relief. If the court determines that no, this is not non-disclosable stuff, and give it over to the defense, it then knocks down one level to one counsel only level. It's still somewhat protected, but we can use it for If the appeals court affirms the trial court, the defendant may not be retried unless new evidence is discovered that they could not have reasonably obtained prior to trial. And the state is barred from proceeding on with the case if evidence is suppressed. Okay, if the Court of Appeals affirms the trial court in suppressing the evidence, they are barred from going forward on the case unless there's some new discovery, new evidence that could have gotten earlier. Witness list doesn't change at all. Basically, the witness list is there. If we have 20 witnesses on our discovery, we call 2. Prosecution cannot read off our list and say, and this is current for those of you who have not tried a criminal case, you can't comment and say, well, Susie Smith, James Smith, and John Doe were on here, why did the other side call them? You can't do that. But as you can today, if the door is open and it's brought into evidence, that, hey, this other witness was there, this other person was there, we can obviously make comment on that. Where are they? Now here is kind of the heart of it all, and this is really, I think, what opened up the door to these negotiations. The first question that was asked 2.5 to 3 years ago was, wait a second, we have to give you all this stuff, and if you're saying that the reason we should is to eliminate gamesmanship, where's the other side to this? And I think that what really got this moving was the recognition that, yes, in order to remove gamesmanship from our system, there does need to be reciprocal obligation. And that is now for the first time kind of how we've gotten so far along in this process. Defense counsel has to give over the lab and hospital reports they intend to introduce, results of physical events, same stuff we have to do now, evidence that negates the guilt of the defendant. The one that's different, written or reported statements by a witness in the defendant's case in chief that is reasonably expected to be called later on during trial. That's something now that many of you know, if we take statements, they can just stay in our file, and that's not to be disclosed. We can call our witness, know that we have those statements in our file, and that doesn't have to be turned over, but it does in this rule now. So there really has to be a good study of these rules, and people may start thinking about how they're doing their investigations and how they're having their private investigators go out.
Does the written or recorded statement in the defense file include like summaries that you take? I mean, you don't have the witness write out a statement, but you have your investigator yourself write a summary of what the person's telling you. Is that subject to disclosure of the rules?
Right. No, I think that what we would have at that point is right here, 16F, and what's not required to go over. That's a great question. I think then what you're talking about is probably work product material. And so any work product material does not have to be exchanged by either party. Transcripts of grand jury are still governed by Criminal Rule 6. Material subject to privilege, confidentiality. I think that would still be in there. So if you're doing your summaries, you're getting ready for your trial, that stuff's not going over.